Forget the cartoon version of this story for a second, because the real danger around Kash Patel is not one dramatic gasp in one courtroom. It is something quieter, colder, and far more serious, a pattern in which public claims collided with legal process, delay tactics met a hard judicial wall, and a federal judge put into the record language no top law enforcement official ever wants attached to his name. When a judge says a witness's behavior is unacceptable and borders on the contemptuous, that is not cable news theater. That is the system telling you the line has been reached, and the next step depends on whether the witness respects the law or dares the court to enforce it. To understand why this matters, you have to go back to the Mar-a-Lago classified documents investigation. Patel had made public claims that Donald Trump had declassified materials found at the resort, even though no evidence surfaced to support that argument in court. When prosecutors wanted sworn testimony, Patel did what many lawyers would advise in a high-risk situation. He invoked the Fifth Amendment before a grand jury. That point matters because taking the Fifth is not an admission of guilt. It is a constitutional protection. But it also creates a fork in the road. Once prosecutors decide your testimony is important enough, they can seek limited immunity, and if a judge grants that protection, the legal ground shifts fast. Patel was ultimately granted immunity so he could be compelled to testify. That is where the warning before jail language starts to make sense in legal terms, even if the internet often turns it into clickbait. According to court records later highlighted by Law and Crime, U.S. District Judge Beryl Howell rejected Patel's efforts to delay his grand jury appearance. She noted that the government had already shown flexibility, including granting extra time and offering scheduling options around his lawyer's trial obligations. The judge said Patel had rejected those accommodations and was instead seeking to delay his testimony indefinitely. Her words were blunt, that conduct was unacceptable and borders on the contemptuous. In plain English, the court was saying this was no longer a normal scheduling dispute. It was becoming a test of whether a witness could keep pushing the system without consequence. If you want coverage that keeps following these power fights past the headline and into the actual records, subscribe and stay close, because this is exactly where the real story lives. Now notice what happened next, because this is where legal process becomes a pressure chamber. The court directed Patel to appear. More motions followed. More arguments were made. And eventually the Justice Department secured limited immunity after a judge ruled that was the only way to compel his testimony. That sequence tells you a lot. Courts do not jump to compulsion lightly, especially when a witness has invoked constitutional rights. But they also do not allow those rights to be transformed into an endless shield once immunity removes the risk of self-incrimination. The system bends over backward to protect the witness first. Only after that does it start asking whether refusal has become defiance. That is why a hard judicial rebuke matters so much. It signals that patience is running out, and in federal court, patience is not infinite. There is another layer that makes this story more serious than one old courtroom clash. Reuters later reported that the special counsel investigation involving Patel was broader than previously understood. 2 grand jury subpoenas to Verizon sought extensive records, including call logs, text metadata, usernames, IP addresses, subscriber information, and even financial details over long time periods stretching across the Trump documents and election interference investigations. Reuters could not determine the precise allegations being examined against Patel, and that distinction is important. An investigation is not a conviction. A subpoena is not proof of wrongdoing, but it does tell you the scrutiny was real, broad, and formal. This was not gossip, not a cable panel, not a political rival talking trash. This was federal investigative machinery operating under court supervision. So when people ask whether the pressure on Patel was serious, the answer is yes, and the paper trail shows it. I want to hear your take here. When a public figure makes sweeping claims in public but fights hard against sworn scrutiny, does that read to you as caution, strategy, or something more troubling? This is also the moment to slow down and be fair, because fairness is what separates analysis from propaganda. Patel, like anyone else, had the right to legal counsel. He had the right to challenge process. He had the right to invoke the Fifth Amendment. Those protections are not loopholes. They are part of the system. If we only defend those rights for people we like, then we do not actually believe in rights at all. So the issue is not that Patel asserted legal protections. The issue is what happened after the court weighed those protections, the government adjusted by granting immunity, and the judge concluded the delay efforts had crossed into territory she considered nearly contemptuous. At that point, the story stops being about rights alone and becomes a story about compliance with a lawful order. And that word contempt needs to be understood in normal language because it gets thrown around loosely. In everyday conversation, contempt sounds like attitude. In court, it can become a mechanism. Federal grand jury proceedings are secret for a reason. Rule 6 of the Federal Rules of Criminal Procedure reflects that secrecy and allows matters like immunity orders and compliance disputes to be handled under seal, precisely because public disclosure can damage investigations, expose witnesses, or taint proceedings. That means the public often sees only fragments. But what we do know is enough to understand the structure. A witness can resist. A court can review. Immunity can be granted. And then the question becomes brutally simple: will the witness testify or not? Share this with someone who still thinks these courtroom fights are just partisan spectacle, because the rules being tested here will still be here long after the personalities are gone. Under federal law, once a witness receives an immunity order, that witness generally cannot keep refusing to testify on self-incrimination grounds. The trade is direct. The government gets the testimony. The witness gets protection from having that compelled testimony used against him in a criminal case, except for things like perjury, false statements, or failure to comply with the order. That last part matters more than most headlines explain. Immunity does not create a free pass to Stonewall. It removes one excuse for silence. After that, the risk changes. The threat is no longer mainly self-incrimination. The threat becomes contempt, sanctions, or exposure if the witness lies. So when people use the phrase "before jail," the sober version is this: jail becomes a real possibility not because a witness annoyed a judge, but because a witness, after legal safeguards are provided, still refuses a lawful order. That distinction is why the Patel story is bigger than one man. It is about how democratic systems handle loyal insiders who move between politics, media, and law enforcement while carrying enormous public influence. Patel was not some unknown functionary. He was a prominent defender of Trump, a former national security official, and later the head of the FBI. When someone with that profile treats judicial demands as negotiable, the damage is not confined to a docket entry. It changes public expectations. It teaches supporters that compliance is optional if you are powerful enough, loud enough, or politically useful enough. That is how trust erodes, not through one spectacular collapse, but through repeated signals that rules are for other people. And then, as Patel's public career kept moving, new controversies kept piling onto that same basic question of judgment. In 2025, CNN reported that he posted a photo on X showing the handcuffed escort of Wisconsin Judge Hannah Dugan after her arrest on charges tied to allegedly obstructing immigration agents. Patel captioned it, "No one is above the law." Critics, including former Attorney General Eric Holder, argued the post may have violated Justice Department norms that generally discourage voluntarily disclosing a defendant's photograph unless it serves a law enforcement function or is already part of the public record. Whether one agrees with the post or not, the deeper issue is clear. The head of the FBI was treating a defendant image as public messaging fuel in a politically explosive case involving a judge. That is not a small optics error. That is a statement about how power wants to be seen. Stay with me, because this is where the story stops being personal drama and starts becoming a warning about institutional habits. The pattern continued in another courtroom, this time in a defamation case Patel himself brought. In 2026, a federal judge in Houston dismissed Patel's lawsuit against former FBI official Frank Figliuzzi over a televised remark that Patel had been seen in nightclubs more than at FBI headquarters. The judge ruled that the statement was rhetorical hyperbole and not actionable defamation. Again, that does not prove Patel's critics right about every allegation. What it does show is a recurring cycle: public combat, legal escalation, and then a judicial system that keeps pushing back on the most inflated versions of the claim. Every time that happens, the image of invincibility weakens. Courts do not care much about branding. They care about standards, burdens, and the actual wording of the law. And if you think serious accountability reporting deserves more reach than easy outrage, use the like button to help push this conversation in front of people who normally only see the thumbnail version. At this point, a fair counter-argument has to be addressed. Supporters of Patel would say he has been targeted because of who he worked for and what he represents politically. They would argue that Trump allies have faced unusually aggressive scrutiny, that prosecutors often use broad subpoenas, and that media outlets have every incentive to amplify the most damaging interpretation of every conflict. Some would even say that the legal system itself became politicized in the Trump era, and that figures like Patel were bound to face unusually hostile treatment. That argument cannot just be waved away. Any honest analysis has to admit that America's legal and media institutions have been pulled into intense partisan conflict, and public trust in neutral process is badly damaged. But here's the difference between skepticism and denial. Skepticism asks whether the system is being fair. Denial pretends the documented record does not exist. In Patel's case, the record shows he invoked the Fifth. Prosecutors sought immunity. A judge said immunity was the only way to compel his testimony, and another set of court records showed Judge Howell sharply criticizing efforts to delay compliance. Reuters documented broad subpoenas. CNN documented a controversial public post by Patel in an active legal matter. CNBC documented a judge dismissing one of his own lawsuits. You can debate the interpretation of those events. You cannot responsibly erase them. That is why CRUMBLES should not be understood as some tabloid image of a man physically falling apart. It should be understood as the gradual collapse of the idea that forceful public messaging can always outrun legal scrutiny. What makes this story especially important is that Patel is not merely a commentator or activist. He sits at the center of federal law enforcement. That means his relationship to courts matters more, not less. When the head of the FBI appears to treat legal friction as part of a permanent political war, every subordinate official gets a message. Prosecutors get a message, agents get a message, judges get a message, and the public gets one too. The message is that institutional legitimacy is now just another battlefield, another thing to weaponize, another audience to dominate. That is dangerous because institutions only work when even their most powerful players act as though the procedures mean something on their own, not only when they produce a politically convenient result. Look at how this plays out in public hearings. Reuters reported that Democratic lawmakers pressed Patel over allegations in an Atlantic article that episodes of excessive drinking interfered with his leadership. Patel denied the report and called it a farce. He also lashed back at critics in personal terms. Again, the key point is not that allegations equal guilt. They do not. Patel has sued over some of these claims, and those suits are part of his legal response. But the broader pattern is impossible to miss. When scrutiny rises, the response is often not calm institutional restraint, but immediate combat, image management, and counterattack. I also want this community's view on that line between lawful secrecy and public trust, because a healthy democracy depends on citizens arguing where accountability should begin and where power should stop. That matters because public institutions run on more than formal authority. They run on behavioral expectations. A judge does not need to jail someone every time to deliver a warning that lands. Often the warning is the order itself, the denial of the motion, the written rebuke, the record preserved for history. In some ways, that is more powerful than a dramatic sanction. Jail can be spun as martyrdom by loyal supporters. A written judicial finding that your conduct bordered on contempt is harder to spin away because it lives in the legal bloodstream. It can be cited, it can be revisited. It can shape how later conflicts are understood. It becomes part of the architecture of credibility, and credibility is everything when a public official wants the country to trust him with the machinery of justice. There is also a human angle here that gets lost in all the partisan noise. When public officials fight process this hard, ordinary people draw lessons from it. Some learn that courts are fake unless they get the outcome they want. Some learn that the Fifth Amendment is suspicious when their enemies use it and sacred when their allies use it. Some learn that "no one is above the law" is a slogan you post about your opponents, not a principle you submit yourself to when the subpoena arrives. That is how civic culture breaks down. The public starts copying the double standard of the elite. And once that habit sets in, every future legal dispute becomes a tribal loyalty test instead of a search for truth. This is why the Patel story should not be reduced to whether one judge was harsh, or whether one witness was stubborn, or whether one headline goes too far. The larger issue is whether the American system still has the nerve to apply its own rules when politically connected insiders push back. In the Mar-a-Lago investigation, the system did what it is designed to do. It gave room for rights claims. It weighed motions. It granted immunity. It compelled testimony. It documented resistance. That is how constitutional government is supposed to work under stress. The problem begins when the public sees that entire sequence and still thinks the only thing that matters is whose side the witness is on. And then there is the question of what comes next. ABC News documented Patel's combative exchanges with lawmakers over the Epstein files, where he argued the FBI had released everything courts allowed and accused critics of misdirection or worse. Reasonable people can disagree about how much can legally be released, and courts do place real limits on disclosure. But the exchange showed something familiar. Even when Patel invokes the law, he often does so inside a posture of confrontation rather than stewardship. That distinction matters. A public servant can defend legal limits without sounding like he is at war with oversight itself. And if you have stayed with this story all the way through, thank you, because long attention is the only way complex accountability stories survive in a culture trained to skim past the hard parts. So, was there a literal final warning before jail in the movie trailer sense that some channels promise? The documented record does not support that exact cinematic framing. What it does support is something more important. A federal judge explicitly rebuked Patel's conduct in the grand jury fight and described it in terms that brushed up against contempt. The Justice Department then took the extraordinary step of granting immunity to compel testimony. Under federal law, once immunity is granted, refusal can open the door to contempt consequences. That is the real legal backbone behind the dramatic headline. Not fantasy. Not a made-up perp walk into a cell. A plain, escalating sequence in which the system signaled that excuses were running out and compliance was no longer optional. And that is why this story remains politically explosive. If Patel is treated as a victim by supporters and as proof of corruption by critics, the country learns nothing. The real lesson is harder and less satisfying. Rights matter. Process matters. Delay tactics exist. Prosecutors can overreach. Courts can correct. Immunity can compel. Written judicial rebukes can become historic signals. Every one of those things can be true at the same time. The challenge for a democracy is to hold all of them together without collapsing into team sports. That is difficult work. It demands patience, and patience is now one of the rarest political virtues in America. In the end, the most revealing word in this entire story may not be jail. It may be warning. A warning is what comes before the full force of the system. It is the moment when law still leaves room for a person to step back, comply, and re-enter the process without forcing a constitutional showdown. Judges issue warnings because courts prefer obedience to drama. They prefer records to theatrics, testimony to martyrdom, procedure to chaos. When a public official ignores that warning, the danger is not just to himself. It is to the idea that law can still govern ambition. And when the official in question helps lead the nation's most powerful law enforcement agency, that warning does not belong only to him. It belongs to everyone watching, because the rule of law survives only if the people who wield power are seen submitting to it before they demand that everyone else do the same.